Hi guys, it's Kathy. I hope you're doing well. My cats are fighting. Kelly, thank you so much for calling me. I really, really appreciate it. I do. Kelly's not supposed to talk. And then she called me. Yep. We love Kelly. Alright, court cases. I like this judge. Here we go.
Ms. Hamilton, is there a reason you're appearing late in my courtroom?
Your Honor, I had tomorrow as court. I missed the switch from Tuesday to Monday. So that's why, and I am so sorry. I don't know how I missed that. I had tomorrow as our docket day on my calendar.
Ms. Hamilton, this is a repeated problem, so I want to make it clear that this is not acceptable going forward, and I know other judges have warned you about it as well.
Your Honor, I missed the day. I do apologize. This isn't a matter of me being late. It's a matter of having the wrong day in my head and on my calendar. I do apologize.
Ms. Hamilton, I would accept that explanation if it wasn't a repeated thing that is ongoing in this courtroom in front of multiple judges and in Fremont County. So I want to make it clear, I am not accepting it going forward. If the court needs to start issuing orders so that you appear 15 minutes prior to our actual court time, the court will do so. I don't want to have to go to that measure, but this is an ongoing issue. My dockets are continually delayed because you repeatedly do not appear on time. So I want to make that clear going forward. With that, the court is going to call 26 CR 08, the People versus Wayne Hall.
Judge, it looks like Mr. I don't know if it's Belle Isle or Isle, I'm not sure, but he's got a pending traffic matter out of Pueblo County. He has that 26M8 case here, the VPO that recently happened and recently charged. This case, 25 CR 19 with the verdicts. He does have a 21M resisting arrest. Looks like also out of Custer County. In that particular case, it looks like he was put on probation in 2021 for 18 months. There was a suspended jail of 180 days. He did actually serve 10 days jail and receive credit for time served. There's a 20M18 child abuse M3 case. Looks like also out of Custer County. It was a deferred sentence as of 2021 for 18 months. And that's the history that I have to offer to the court.
All right. Thank you, Mr. Lindsay.
I think that the most noteworthy thing from the people's perspective is Mr. Belle Isle had a chance to avoid this confrontation. He had a chance to avoid himself getting shot, to go to that extreme to trespass onto somebody's property, to be warned numerous times that he's going to be shot and then be shot, and still, even after the tourniquet is being applied, to continue to argue and fight. It just doesn't make sense. It doesn't sound like a rational human being that is operating under those circumstances. Mr. Belle Isle, once he engaged in the assault, picked up a stick and started hitting Mr. Terra, could have been killed. He could have been shot, and that wouldn't have been anything other than a lengthy investigation that ultimately would have more than likely determined that Mr. Terra was acting in self-defense, and Mr. Belle Isle was not a victim of, other than being shot. He was the initial aggressor, and the initial aggressor is not entitled to self-defense at that point in time. It just, again, coming back to the things that have happened since, a new protection order. There are protection orders that I'm communicating with the sheriff's office that are pending, that are being sent to me. Judge, we think a 60-day jail sentence is appropriate. We ask that the court put Mr. Belle Isle on probation for as long as humanly possible in this jurisdiction. We ask that the court very much reprimand him and tell him there's no contact with Mr. Terra, Mr. Terra's wife and children. There's no contact with this property. There's no contact with the easement. But this is the kind of case that we unfortunately seem to have more often than not in these smaller jurisdictions where people just do what they want to do and have no response to the law, response to what's property rights are. And we just can't have that happen. We got to have people respecting property rights and obeying the law. My understanding during the trial, Mr. Belial was unrepentant.
I'm sorry. He didn't testify.
Okay. My
Ms.
understanding,
Hamilton, you're going to get the chance to speak
I understand.
and you can make your argument. You're not going to cut off right in the middle.
I'm not trying to cut him off.
That's exactly what you just did, and I'm making it clear now, Ms. Hamilton. I'll give you the chance to make your argument.
I understand.
You're not going to cut counsel off.
and I apologize, Judge, after the trial and the verdict, Mr. Belial was very upset with being held accountable, being found guilty. And that's what I meant to say. And that's according to Mr. Tommy, who tried the case. Judge, I don't have anything else to add. I would ask if there's any restitution as a result of this case.
None at this time.
No restitution. Thank you. That's all I have.
Thank you. Ms. Hamilton, argument.
Your Honor, I don't know anything about this being unrepentant, being angry. I've heard nothing about any continuing violations of protection order. How can I respond to these vague assertions that I know nothing about, there's no evidence of, haven't been charged yet? I don't know what's being referred to, that Mr. Belial was not happy. I walked out of the courthouse with him after the trial. He said nothing to anybody other than me. So I'm concerned about the misrepresentations that have been made, and I apologize for interrupting. What I heard the DA say just now was that during trial, he was unrepentant. The reason that
That's my
I had a
pleasure.
strong reaction to that is he didn't even testify, and he has not at any point in this court during that trial or after displayed anything like that. So I don't understand where these assertions are coming from. Now, in terms of the actual case that was brought to trial in front of a jury, Mr. Terra and the state have managed to paint Mr. Belial as just the 100% cause of every issue, all the problems. He got himself shot. Wow. The one-sidedness of this is striking. And this idea that Mr. Belial has caused every tension, every issue with any sort of property dispute, it's all on him. Where's the mutual responsibility to maintain neighborly communications, to resolve issues in the best way possible? Instead, we've got numerous calls to officers over and over and over. I'm hearing 20 new VPOs or 8. This is out of hand.
Yeah. 20 new VPOs is out of hand, woman. Yes, you're right. He violated protection order 20 times.
And I don't disagree that, especially in Custer County, any issue when we're talking about property, it can be a hot button issue. And I even talked to the jury, the potential jurors, about that during voir dire. It is a big issue up here. It's concerning that people carry guns and are ready to shoot other people who come 20 feet into their property. It's a tense and hot button issue for sure. I think Mr. Belial understands that. Mr. Terra was not the only one frightened that day. Mr. Belial, whatever the jury determined about who was the first aggressor or not, the fact is Mr. Belial grabbed a stick in the realization that there was a gun. and that the gun was being pointed at him. So we can he said all day long, but that is, at the end of the day, we had a stick versus a gun. And my client did what he felt he had to do, and that is still the case, regardless of whether the jury thought that self-defense was not proven, that non-self-defense was not proven, or regardless of how they saw it. Certainly, we see it differently. That's beside the point. At this time, Your Honor, Mr. Belle-Isle is also frightened. He understands the protection orders. He's intelligent. He knows what the rules are. He understands that. Does he think he's been treated fairly? No. But this isn't a matter of not willing to follow orders or rules. That's not the issue here. He is repeatedly being beat down, accused of things constantly all the time, especially now. So when we talk about who's ramping up, I'm concerned that it's actually Mr. Terra and not necessarily my client ramping things up. Most especially because I didn't hear anything specific. What are we talking about? Are we talking about continued threats? Are we talking about messages left? Are we talking, or are we just talking about Mr. Belle-Isle driving down the road that he lives on? This is the place we're in now, where everything he does seems to be a concern and a threat. That's just not the case, Your Honor. He got shot. He was there with his 5-year-old son and his wife. He was not there to cause trouble. He wasn't there to do whatever he wants and make a big display of how he can have and be on this property. That's just not the truth. And it's not how this played out. Certainly there did end up being an altercation that nobody denies. I'm asking Your Honor to consider a short probation period. Mr. Belle-Isle has civil issues to figure out, property issues. He's being attacked from all different directions with respect to not just this incident and these criminal type allegations, but the property. It seems like there's a plan for these properties to perhaps move my client out of there somehow and maybe take over and develop the properties that he was living on. I'm not sure why this has gotten to this point. I don't disagree with the DA that it is concerning and it needs to die down. The temperature needs to cool. I don't think anyone disagrees there. I think my client is looking at different options for how to accomplish that. I'm asking, again, just for a period of probation, Your Honor, for these cases. Thank you. And I do believe my client wishes to address the court. I just want to advise you again on the record. Want to be careful about talking about facts of things that haven't been charged. Thank you. Thank you, Your Honor.
Thank you. Mr. Belle-Isle?
Good morning. Since all this, I've gotten security cameras at my house. I've been violated by people around that neighborhood. I can't say if there's connections to Mr. Peter, but my house has been robbed for all my tools and everything, my business. Like I said, I don't know if they're his friends, but they came to my house. They took all my tools. They've tried to
That
do
was my
anything they
sister.
could to bring
Sorry,
my
sir.
business down. Just the other day, there was a report and I didn't even know about it. And then come to find out that it was at my neighbor's house when Mr. Pete Terra said that there was an incident that happened. And there's a witness that wrote a letter because she was there while Mr. Terra made this report. And she said, and me, that none of this happened completely. She was there the whole time. And so, and we're having problems with him trespassing every single day. There's rocks falling in my yard and everything else. So we're just trying to, I've done everything I could to protect myself at my house with the cameras. I was able to show guilt because I do have cameras, which before I was innocent, and I wasn't able to show guilt because I didn't have anything to show guilt with.
I think you're talking in reverse.
Okay, Yes, but I went ahead and
Show guilt? For what? I'm sorry, I just want to make sure we're clear. Showing what guilt?
well, I mean, like in just in general, like
Okay.
I can't prove nothing because I didn't have any cameras. So what I recently did is when I found out about the call the other day, and I talked to my neighbor because she was right there. She's an older lady. They're older people, Doug. I go over there to help them out and everything. She was really concerned about the false report that Pete did because she was there, and so was I. So I turned around yesterday. The only way I can cover my butt is if I have a recorder on me. So yesterday I went to Best Buy. I went ahead and put a recorder in my truck. It records the front of my truck, it records the back of my truck, and it records the cab of my truck. So from now on, there will be a recording all the time of me going up and down that road or anytime I'm at my house, so I can go ahead and show what's going on when I'm convicted or when I'm, when everybody says that you're doing this and that, and I'm not. I mean, I about lost my life, my business through all this, getting my house robbed and everything else. I mean, it's one thing after another that it just keeps escalating. And my wife finally got a civil lawyer, and we're like, enough is enough. And the only thing that we can do to protect ourselves is to get a camera in my truck. And I am leaving I got a house in Colorado Springs. So by the end of next week, I will be leaving until the civil suit goes through. And that's guaranteed I'll be leaving. And then once the civil suit goes through, I hope that you guys see, I mean, between the neighbor and everything, it'll show that, there's false accusations and things aren't the way they seem to be. It'll show proof on that. Thank you.
Thank you, Mr. Belle Isle. Court has considered the factors for sentencing as laid out in the statute. It is concerning to me the lack of accountability that is being taken on behalf of Mr. Belle Isle regarding his actions on the date in question in this case, in which a jury ultimately did not find that Mr. Belle Isle was acting in self-defense and did convict him of multiple charges. And yet before the court today, there's still no accountability, no responsibility taken for his own actions. I want to make it clear, the court recognizes that in these smaller counties in which law enforcement resources are limited and geography is far spread, or the county ultimately covers a large amount of many, many miles for a limited law enforcement response, it is a constitutional right for individuals to bear arms. It's certainly not a right for them to commit crimes while bearing arms. However, that is not the circumstance before the court ultimately. To claim that it's not okay for neighbors to ultimately be on their own property with a firearm is just flies in the face of the Constitution, quite frankly. And ultimately, when law enforcement is such has a limited response because of limited resources, it ultimately does lead to folks having to defend themselves in situations where law enforcement can't be there right away. I am finding certainly there was a law enforcement response in this case. So I guess I want to make sure that is clarified. I think much of what the court heard today is argument from Mr. Belle Isle that he is the victim of these circumstances, which is not what a jury of his peers ultimately found. So the court does have some concerns about the lack of accountability.
Can I talk, Your Honor?
No, I'm issuing my orders, so no, you cannot.
Sorry.
You had your chance to speak.
Sir, she's super annoyed with your lawyer, so you cannot speak.
So I am concerned. I do have victim safety concerns here. I do have concerns. The purpose of rehabilitation is if someone is recognizing their actions and recognizing wanting to change, and the court hasn't heard that from the defense at this point, and the defense opted to make statements. Court is going to impose a probationary sentence. I am going to impose a 2-year supervised probation sentence. That will include a substance abuse evaluation with compliance with any treatment, a mental health evaluation and compliance with any treatment. There will be the standard terms and conditions of probation to include monitored sobriety at probation's discretion. That you shall not possess or purchase a firearm while this probationary sentence is pending. Will be random, as I indicated, monitored sobriety through random urinary analysis or breath analysis. There'll be court costs and fees. I am also imposing a 30-day jail sentence as a condition of probation. And the court is finding that's going to be appropriate so that Mr. Belle-Isle can reflect and recognize that his actions on this date in question were criminal, and a jury ultimately found that. So in regards to false accusations, not in this case. A jury found that these accusations were proven beyond a reasonable doubt. And that is the reality before the court. I am willing to give a brief stay of execution, given that Mr. Belle-Isle indicated he is in the process of moving. I think that will certainly help quell tensions. So Mr. Belle-Isle, what does your schedule look like for that if I'm going to grant you some time before turning yourself in for that 30-day jail sentence?
I have a couple weeks. At least like 3 weeks.
So what I'm going to order is that no later than noon on July 1st, you are to turn yourself into the jail. I am suspending an additional 60 days of jail or 30 days of jail on the condition that you turn yourself into the jail by that date and time. Or to the Custer County Sheriff's Office by that date and time. And I do want to make it very clear, Mr. Belle-Isle, there is a protection order in this case. If I find, based on the starting of this probationary sentence, or ultimately if it's found that, and you are convicted of a violation of a protection order while you are on probation, I want to make it very clear, I am unlikely to consider a regrant of probation, and you are facing potential sentencing of up to, with my math, over 1.5 years of potential jail time that the court could impose. So I want to make that clear. I am imposing that sentence for both count 1 and count 2. Those will run concurrent to each other. Count 3, I am imposing 10 days jail concurrent to count 1 and count 2 with a stay of execution until July 1st at 5 p.m.
And Your Honor, for the record, we will be asking to stay the execution of that sentence pending appeal. I will file written, now that he's been sentenced, I will ask that that sentence be stayed, and I will be filing a notice of appeal later today.
Deny.
That's not a motion before the court at this point in time, so I'll let you file that motion for stay of the sentence.
It's going to be
I understood
denied.
that it could be a verbal motion, but yes, I will follow up with a written. Thank you very much.
Court is finding there's no restitution. There will be court costs and fees, and there will be some supervision fees for probation, but otherwise the court is not imposing any additional fines. Anything else to address today, Mr. Lindsay?
No, thank you, Judge.
Ms. Hamilton?
No, thank you, Your Honor.
Those will be the orders of the court.
So that's all I got from this judge. That's all I was going to get from this judge. But I enjoyed her yelling at Miss Hamilton. So I added the next clip too. I left it in. I don't know if it's good, bad, or not, but I just like the judge.
Okay, so let me get that.
Give me just 1
Court will
second.
call the Custer County Advisement Docket.
Take care. Easy.
Sheriff's Office.
Mr. Hinton, I'm going to advise you generally, and then I'll call your case specifically. Court would note for the record that for advisement today, Mr. Lindsay is here on behalf of the people and Mr. Wyman is present as alternate defense counsel should Mr. Hinton be requesting court-appointed counsel. Or Mr. Wyman, I'm sorry, this happened pretty fast this morning. Were you representing Mr. Hinton or Ms. Barrows today? I'm sorry, Mr. Wyman, you were muted during that time. I didn't catch your record.
Ms. Barrows, Your Honor.
Ms. Barrows, okay. I'll call that case then in just a minute. I've been notified from the jail that Ms. Barrows refused transport.
And Your Honor, that's correct. Our office can accept appointment for Mr. Hinton.
Mr. Hinton, you have the right to remain silent and you should remain silent as all of these proceedings are being recorded and anything you say could be used against you. You have the right to an attorney and for the purposes of today's proceeding, you have a right to the public defender. If the public defender has a conflict, I would appoint other court-appointed counsel for you. Alternatively, you have the right to hire your own attorney. You have the right to know the nature of the charges against you, and if that is not waived when I call your case, I will tell you what the charges are and what the possible penalties are. You have the right to enter a plea of not guilty and to have a trial to either a judge or a jury. You have a right to be represented by your attorney throughout the case, including trial and sentencing if necessary. If you enter a plea at some point, any plea you enter must be voluntary. It cannot be the result of any undue influence, coercion, or force on the part of anyone else. You have the right to be at liberty by posting bond, and that is why we're here today to talk about bond. If you choose to say anything today, you should limit your remarks to the issue of bond and not the charges that have been brought against you. You are presumed innocent of the charges pending against you, and that presumption of innocence remains until the prosecution has presented evidence sufficient to prove you guilty beyond a reasonable doubt. At trial, you have the right to confront witnesses who are called to testify and to cross-examine those witnesses. You have the right to present your own evidence and your own defense, and if you choose to do so, you can utilize court orders or subpoenas to compel the attendance and testimony of witnesses. You have the right to remain silent at that trial or the right to testify, but if you choose to remain silent, the jury would be instructed they couldn't use that against you in any way. And if ultimately you are convicted of anything after a trial, you would have the right to appeal that conviction to a higher court. If you have been charged with a criminal violation, a mandatory protection order will enter today that restrains you from harassing, molesting, intimidating, or retaliating against any alleged victim or witness to the offense. A violation of that may result in more criminal charges or a charge of contempt of court. If you have been charged with a felony, you may be entitled to a preliminary hearing, and you may be entitled to that hearing within 35 days of the day you make that demand, but that is a proceeding you should discuss with your attorney, as your attorney will have to prepare for that hearing. You should know that conviction of certain offenses can adversely affect your immigration status if you are not a U.S. citizen, and you should discuss your immigration status with your attorney before you enter a plea. If you are currently serving in the armed forces of the United States or you are a veteran of the armed forces, you may be entitled to substance abuse treatment, mental health treatment, or other services. And if you believe you qualify for that, you should contact your local veteran services office and notify the court. If you are a veteran and you are convicted of an offense as a result of your arrest and placed on probation, you may be able to petition that probation to a jurisdiction with the Veterans Treatment Court. Court will call 26 CR 12, the People versus Jeremiah Hinton. Mr. Hinton, I'm unmuting you. If you could just state your name for the record.
Yeah, it's Jeremiah Joseph Hinton.
Mr. Hinton, would you like the Office of the Public Defender to represent you for the purposes of today's proceeding?
Yes.
Ms. Hamilton, are you willing to accept appointment and waive any further reading and advisement?
Yes, Judge. One of our interns was able to speak with Mr. Hinton, I believe, and I have notes to go forward and argue bond.
I did not find probable cause as to the violation of a protection order allegation, but argument on bond regarding the two remaining arrest charges. Mr. Lindsay?
Judge, it looks like Mr. Hinton is on probation in 24 CR 106. He was placed on probation for a DM1 that looks like on June 17th of 2024. That was revoked a little over a year later, July 24th of 2025, and regranted probation for 12 months. He is pending a second revocation here, complaint in that case, where he just really hasn't done anything. The allegations are he continues to use illegal substances. He's not submitted to testing, and he's not done any treatment. So based on his performance in that case and the charges in this case, we were asking for $1,000 cash or surety bond. Thank you, Judge.
Thank you, Mr. Lindsay. Ms. Hamilton?
Your Honor, I understand that Mr. Hinton lives in Canyon City with his mother and his brother. So he is connected in the community. The family situation is a significant one, putting a lot of pressure on him. Specifically, his mother that he lives with is 76 years old, and depends on him for supporting the household, taking care of the household. And he's concerned about her and her ability to do everything that's needed without him there. That is especially the case because his brother does unfortunately have cerebral palsy. The care of his brother, I understand from the notes, does require two people, mom and Mr. Hinton. So obviously that's on his mind, and he does need to be at home to help out. Your Honor, my understanding of his employment situation, he is employed by Public Partnerships Limited for home health care. That's presumably for his brother. He does nursing, bathing, housekeeping, and he's been paid for that for about 4 years. So it's not only his obligation to his family, but it is his job as well. He does support through child support payments 3 children in Arizona. They are 17, 13, and 11. He has had some college. Again, he's very concerned about the situation at home. He is concerned about this case. He wants to be engaged and taking care of the case in the best way that he can, as quickly as he can. And Your Honor, for all of that being said, I would ask that Your Honor consider a PR bond for him. Also, especially noting that he's on probation and will be needing to report to that supervision when out of custody. Thank you, Judge.
Thank you, Ms. Hamilton. Court recognizes certainly that Mr. Hinton is on probation in 2 cases, both Fremont County and Pueblo County. The Fremont County case is pending a revocation at this point in time. The court is also finding that Mr. Hinton has 5 failures to appear within the last 2 years. So the court does have concerns about Mr. Hinton's ability to appear for court in the future. Court will set bond in the amount of $500 cash or surety. I am imposing bond conditions to include that Mr. Hinton shall appear for all court dates in person, that he may not commit a felony while on bond, that he must sign a waiver of extradition, that he may not leave Colorado without court permission, that he may not possess or consume alcohol or controlled substances without a valid prescription, that he must complete monitored sobriety with random testing twice per week. Mr. Hinton, if you sign a release with the Custer County Sheriff's Office, you might ultimately be able to have your testing for probation qualify for that monitored sobriety as a condition of your bond in this case. Mr. Hinton's next court date will be July 7th at 10 a.m. And those will be the orders of the court.
Thank you, Judge.
The court will next call 26M15, the People versus Gloria Barrows. Mr. Wyman appears for Ms. Barrows. Mr. Lindsay is here on behalf of the people. We've been informed that Ms. Barrows has refused. Mr. Wyman, I guess ultimately the court would like to address probable cause as I have some concerns. And so I'm willing to address those today. If you are willing to waive your client's appearance, she will still be advised beyond the probable cause arguments tomorrow. Or we can address it tomorrow.
Morning, Your Honor. I did speak with Ms. Barrow. She told me she was not feeling well today. That's why she's not here. So I would ask to waive her appearance this morning.
Mr. Lindsay, if I can get some argument regarding probable cause.
Just a moment, Judge, please.
Sure.
Judge, I do suggest that there is probable cause. I do realize it's a little bit skinny. However, when they searched the vehicle in her purse, they did find several loaded syringes. Given the fact that there was fentanyl pills found separate from her purse, tin foils, front pockets, some smoked and unsmoked, also grams of methamphetamine, I would argue that the probable cause exists that those syringes, those loaded syringes are more than likely methamphetamine. That's all I have, Judge.
Mr. Wyman?
Your Honor, I was just reviewing the probable cause affidavit now. Judge, I'm just taking... I guess I would just defer to the court. I haven't really had the opportunity to review it.
Sir, you
Right.
suck as a lawyer.
Court would note, based on the four corners of the affidavit, that loaded syringes, I certainly recognize if the court went beyond the four corners of the affidavit, that the court might surmise that loaded might mean that it contained a controlled substance, but that evidence is not within the probable cause affidavit, within the four corners of the affidavit, and the court is not finding probable cause for that class 1 drug misdemeanor. As a result, the case will be dismissed.
Don't worry, they'll get to read.
That doesn't dismiss, Mr. Whiteman, just so you're aware, that doesn't dismiss certainly that fugitive justice warrant that was from Fremont County, but just as to the class 1 drug misdemeanor that was alleged in the affidavit in this case.
Thank you, Judge.
All right.
Once
Those
those
will be the orders
results
of the
come
court,
back
and I
from
think
the
that
lab,
concludes our Custer County
Oh, no.
advisement docket. Thank you, everyone.
no, I don't think that'll make a difference. Anyway. All right. This victim statement is just a little long, but it's what happened after the victim statement is over. After you hear all of that, then something happens.
Affidavit. I know those facts. What would you like me to know, sir?
I obviously do not accept this decision. These three need to be held accountable. Freedom is the most precious thing. It is the foundation of being a human, and they trespassed against me. Our friendship, against honor, against dignity and respect. They acted as animals with no sense of humanity, even if it was for a sliver of time. They allowed themselves to be overcome with rage and anger, which was already there, and it consumed them, and they were no longer themselves. A person who has any understanding of compassion and maturity of mind would never just watch a friend, especially, go limp on the ground and unable to get to their feet, and then proceed to stomp them out and kick them altogether. A real brother and a real man would get in between or try to stop these brothers to try bring peace, not join in and beat the SHIT out of him. Then scream, "You're going to jail," as you watch him limp to his car with no care or knowing of his safety. These boys are not men, they are honestly cowards. Forgiven cowards, but nonetheless cowards. They're not even here. They are not anyone who should be representing my community in the town of Paonia or this Norfolk Valley. I'll say it again that I do not agree with this decision. I absolutely want to go to trial. I am not here to be wrathful, but to speak truth and hold them accountable, just as you should feel. I am here to protect my community. I have been a protector and a proactive part of my community for 8 years, doing sweat lodge, prayer circles, building people's homes, playing in bands and live music, working with my elders, physically and cleaning with my family's business. I have earned my place amongst my community, and I have had a reputation to uphold. They have been here just as long and no one has ever known who they are until I introduced them. They came into a loving community that moves a lot differently than they do, and they have been in hiding and they haven't shown their faces because the truth of who they are was immediately seen by my community. I had blocks, and I wanted to see the best in them, which is truly what got me into this situation in the first place. I have come in person because I mean it very deeply that these men are unsafe, violent, and destructive. They need humbling and to be held accountable for coming into my life, my community, and hurting it, causing more pain than they ever did good. In fact, I feared for my life already, and now I must face the music right now, just as they have to. And I've been out of commission for the past 7 months, unable to work because of what these boys have done to me. The last 2 months I've been able to find a few hours in a restaurant, but having to take unscheduled breaks because I can't work for longer than a few hours. I've been hurting in my soul, my heart, and my body. I'm a very strong-minded and strong-spirited man, but this has crushed my pride, my sense of confidence, given me much social anxiety, and made me feel very ashamed that I could ever allow someone so cowardice and destructive, violent, and abusive into my life. I've battled with just giving up on this whole situation because what's the point if you're just going to dismiss it? I'm trying to heal and get this out of my life and move on, absolutely, but not to where they just get to walk away and think that they're allowed to treat people this way. If you don't do it now, you'll do it eventually. Are you really going to ride on the faith that these boys have been truthful and just wait for the moment that someone else has to be a victim of their anger and rage? You have an opportunity now to hold it accountable, to go to trial and push this to the extent of the law, what they deserve. Why wait and let someone else get abused and let these cowards enjoy their freedom when they don't deserve any of it right now? I've walked through the fire many times, and it takes a true man to take accountability for himself. Are you really serving justice? Because to me, it looks like we're about to let 3 guys walk out the door after causing severe bodily injury and not even try to understand their mental state. You want to say it's a waste of time? Well, what about my time? This seems like a whole waste of time if they just get to walk out the door as if nothing happened. It's kind of this room's job to serve the community in a good way, as it was my job to stand up for my community and my home and my morals, and I got hurt doing it. I don't think any of you will. I deserve more than this, to be honest. I deserve to hear every single detail and have every single detail explored. I haven't even heard them speak. I've had to defend myself and stand here twice now to convince this room of the abuse that I've experienced. This is backwards. They should be defending themselves and speaking to this room, given the fact that I have 3 fractures in my pelvis. It's our job as humans to hold each other accountable and bring each other higher if we can have the tools to do so. That's what this room is for. I was afraid of this room and of them, but I'm not anymore. And if you hear anything from these words, it's that I have found forgiveness and I am working on deepening it. I have found love, but I am here to hold this experience accountable. If just one of these boys would look at me, especially Marshall, since he was the ringleader of all of them and egged it all on, and apologized and admitted their wrongs, I wouldn't even need to be here. This wouldn't have even happened. I want them to look at themselves. I want them to see what actually happened here and take accountability for it. And if that means prison time, which I think is at least a mandatory 1 to 2 or more, so be it. If that means rehab, so be it. If that means intensive supervised probation with classes and anger management and learning of relations and a court-ordered restitution, because in this country money seems to buy your freedom, then so be it. That would honestly heal my heart and my mind. I am not here to hurt them. I want them to get help. I also accept that if they walk away from here, I have to trust that the highest above, or whatever you want to call it, will even this playing field. If you don't, they will get what they deserve for being dishonest, unimpeccable, and avoiding this situation entirely. Why this needs to go to trial is because you will see the energy and the character of who I am and who they are very distinctly. I have witnesses of their behavior and women who will advocate, and I know that this is all my case has. I know that this is all that my case has to prove. They're capable of this, and also my injuries because of the lack of witness. It's been 8 months and no one knows really anything about anyone. It's all at face value, and honestly, it's been ridiculous how little communication I've had over the past 8 months with something that is such a heavy situation. So now to speak on how this has truly affected me, well, this injury is going to affect me for the rest of my life. I can't sit on anything without some sort of discomfort and pain. I'm 5 millimeters out of alignment, and luckily I didn't need surgery. I couldn't poop on my own. And my family had to hold me as I leaned on a walker. This was close to 3 months of being unable to leave the room I was in unless supervised, because it was dangerous for me to move and walk or go anywhere. I had to use laxatives and poop standing up because I couldn't do it sitting down because it was so painful. Once I was able to use the toilet, I would sit on it for at least 15 minutes because my muscles were so tense and my body was in so much shock that I couldn't even poop or pee without it hurting me. I peed laying in bed like a vegetable because it was easier that way than having to move around. My little brother is 19 and my younger sister 24. And my mother had to watch me drag my leg behind me because I was incapable of using it, or being able to move upstairs and walk across the room without assistance of a walker or a person sometimes. I became an old man, and this is something I shouldn't have had to experience for another at least 40 to 50 years, or not at all. Do you have any idea what that can do to a young man's heart and mind? It took me close to 3 months to be actually mobile and for it to be safe for me to come down the stairs, walk around the house, and do daily activities such as make coffee and eggs. I'd lose my breath because even the smallest of things took so much to do. My muscles became weak, and I lost 13 pounds over this ordeal. I'm already a skinny, lanky lad, which, to make a point here, the disagreement between Marshall and I, does it really take 3 men that are all larger than me to subdue me, and does it really mean you throw me through the air and stomp me out like a bunch of thugs? I'm 140 pounds, I'm not that big. You really think I was trying to cause a fight with 3 guys in my own home who I knew had weapons? Like, come on now. To have been a man that could climb on roofs, ladders, lift 80 pounds and work 10 to 12-hour days, this has been incredibly hard on my psychology. Before getting to the cane, everything was done for me because I couldn't do anything myself. My sister washed me. And like, have you ever been washed by someone and I thought they were going to be here? Marshall, Eric, or Steven, because you can't do it on your own. I couldn't stand or support myself or get into the bath. How this affected me isn't just the only thing. It affected all of my family, my extended family and friends. They took time off to support me and damaged their hearts and their minds. And we aren't rich, we can't buy a therapist or a nanny. So they experienced it all. And my community got scared. They said, wow, if this can happen to Harry, someone who's strong and is a part of our community and well known and is powerful, then how this could happen to my kids, this could happen to me. My trust has been broken. I have confusion in my heart and in my head on how I even ended up around such foul.
We're about to find out. No matter how much your trust is broken, it can always be broken even more.
People, as well as the constant reminder of not being able to go anywhere or do anything, as they just got to walk around and be free because they had a little money. I have had insane social anxiety and been worrying that people are just going to use me and have an agenda with their actions. I've never felt this way. I've been a very personable person and I've been able to talk to really anyone. It's one of my gifts. My pride and my sense of strength and my sense of self have been affected. But I know that true strength lies right here in these words. The words that they tried to beat into submission, be out of me and take off of this earth, because they would rather hurt me and potentially kill me than change it or look at themselves. What if my head hit those bricks? Just think about that. I could have died, Delta County. I could have died because of their rage and instability. And they still probably would have gotten away with it because I would be dead. And they could still say anything happened, just like they are now. But I'm alive and I'm telling you that it's a lie. These boys are liars. I don't call cops. I like dealing with things with my community. But this, I need your help. I have been working on my compassion and awareness and my sense of manhood for a long time. I've been raised by women. These 3 have no idea how they affect everything around them. I've met some pretty shut off and downright silly people but these lads take the cake. They've never once sat down and looked at themselves and the things that they've done or could do. And if they did, it was a lifetime ago. And these three need ample time to reflect on their negative actions and decisions. They need time to listen to the right voice and figure out why they are in this position, why they are in this room, and why I'm accusing them of such pain and suffering that they could inflict onto not just a stranger, but someone that they called a friend and a brother and lived with and actually shared good memories with. We had a good time until I started to vocalize these things I was seeing and hearing, as well as the things my community was seeing of 8 years. There are massive signs that these three are unstable, narcissistic, dangerous, violent, and thuggish men. Meth is a heavy and disgusting thing, and all three of them have been with it. Marshall's father died last year, or a month or so ago, before this happened, and I almost tried to give him the grace, which is insane. In the sense that I was going to give him grace for why he would hurt me like that. I don't care if your father just died. You don't put 3 fractures in someone's body because of it. You need to go to therapy. Being held accountable means truly taking accountability. And I don't believe for a second that they will ever take accountability for anything they've done. And this is their moment. This is your moment, Marshall, Eric, and Stephen, to actually take charge of your life. Grow up and humble to the fact that you have a lot of work to do and you just severely hurt someone. I am so willing to go to trial and hold that space and face the music. But now it's this, the potential of dismissal, which is honestly, forgive me, pathetic, given the weight of this situation. How do any of you feel even righteous or good enough doing the bare minimum? They need to feel the weight of what it's like to be freedomless. They deserve to have their freedom taken because they don't understand how precious it is. They disrespect everything they touched, and I know they are capable of doing much worse. They could have killed me, and I thank the Lord every day that they didn't. No matter how hard of a text message I sent or the words I was saying the morning of being attacked, it did not warrant me getting 3 fractures in my pelvis and being jumped by 3 grown men. I'm a very spiritual man, and everything in my life has led me to this moment. What it has taken me to get to this place is an incredibly, potentially insane amount of forgiveness. Because at the end of the day, all I want is peace in my heart, and I want them to get help. They shouldn't be focused on life and their jobs and having fun. They need to be 100% focused on fixing their minds and start a new path and a new life that is wholesome. One with deep understanding of what they have just done to me and others. From my perspective, they have so much to learn and unlearn that it can't be done in society. What is peaceful for me is jail time, rehab of an extensive period, intensive supervised probation also, but with classes and court-ordered restitution for the loss of wages and hardship my
Is that Bobby? Is he Bobby?
family has had to experience. On deep levels, these boys need severe help. Right now, I am not angry. It has taken me so much forgiveness and compassion and prayer and healing with the water of the hot springs and talking with my family and extended family and the medicine people in my circle to get here. I can't say I won't feel some type of anger or sadness or disappointment in this system if it does not feel just or fair once I leave this room, but I will accept whichever way it goes because I'll have no choice. So I have to truly believe in this judge and his heart and that he sees what is truly in front of him. However, I need you all to know with the power of my voice and the power within me and my presence that Marshall Polsey, Eric Burton, and Stephen Benson don't deserve a lick of sunlight. And to walk this beautiful gift of a world when they think they can just stomp on it, take what they want from it, and abuse the ones that want what's good for them, and blame the world for why they are the way they are. Behavior such as this, you don't just unlearn it at 33. This is who they are and they need help. So after all of this, I still love. That doesn't mean that I still don't wish to serve justice. I still pray for all 3 of you because that's what a good man does. I'm not here to hurt you, I'm here to hold you accountable because you can't do it yourself. I understand that you are in so much pain that you feel like you could do this to another human. I'm not suffering as much as you are, that's the truth. And that's wild because I just went through a lot of pain to get here. Yes, you hurt me, but you only hurt yourselves. And now you have to live with that. You don't understand that you actually hate yourselves and therefore hated me and beat me. So at the end of the day, you lost. I didn't, because I'm actually facing the music and I'm here, growing and learning as you hide, and continue to live in where your shadow is. To wrap this all up, I want to say that this is one of the most powerful things I've ever experienced, and it's humbled me. It's made me cry and feel very angry, neglected, sad, alone, and mostly misunderstood. At the end of the day, I'm only here to do one thing, and that is to understand who I am, so that I can love and not be afraid. I was just speaking my truth to brothers that I thought loved me, and that I could talk to them about things I couldn't. So I pray that one day you love yourselves and you find that power within you to stop being a good man, be impeccable, to be true and honest, to be kind and gentle, and to not have to be nasty to get your own way. Speaking to myself, I'm speaking in this room, it's our job to be honest and true. Thank you.
All right, thank you, sir. Mr. Allen, can I ask, since it's the people's motion to dismiss, do you want to make any record as to the basis for your request to dismiss?
Yes, Your Honor. After extensive review of this case, and I appreciate Mr. Robinson being here and making his statements there, I think that does take a lot of courage. And while I don't have any doubt that Mr. Robinson's character is that more than of these defendants, looking at this case and the evidence that would come in, because that evidence would not at trial, the people do not believe that we could affirmatively disprove a case of self-defense here. The facts, at least known to the people that are contained in the discovery, is that Mr. Robinson and specifically Mr. Polzin were having an argument, a disagreement that day. All three defendants were attempting to evict Mr. Robinson from the property for just general disputes, roommate disputes. And Mr. Robinson was confronting Mr. Polzin on the staircase. Mr. Polzin was attempting to leave the property when Mr. Robinson confronted him there. An argument ensued. Mr. Robinson then approached Mr. Polzin on the top of the staircase, at which point Mr. Polzin attempted to kick Mr. Robinson away from him. Mr. Robinson then grabbed onto the defendant, and that's when essentially the fight ensued, trying to ultimately they kind of pulled each other down the stairs. It kind of gets muddled at that point. Eventually, Mr. Polzin calls to the other two co-defendants, and they come and get Mr. Robinson off of him, ultimately falling down the stairs and landing on a set of concrete slabs. We do acknowledge that there is serious bodily injury in this case. We're not minimizing Mr. Robinson's injuries at all. I do believe CVC has paid out on some of those medical expenses. Mr. Norb can also elaborate, I think, on some of this. He's provided some witnesses that corroborate some of the statements by the defendants in this case. Mr. Polzin was the one that called law enforcement immediately thereafter. And I believe her name, I think she was one of the property managers. Some of the statements that were made by the co-defendants there would likely come in at trial, corroborating some of their stories. So ultimately, we do not believe that we could affirmatively prove the case beyond a reasonable doubt or disprove a case of self-defense. I think the acts of Mr. Polzin in that conversation could be seen as reasonable self-defense.
I'm sorry, Mr. Allen, did you say that there are witnesses other than the co-defendants that observed things and gave
They didn't
statements?
observe things, but the defendants called them shortly after this incident with some potentially excited utterances and such that corroborate that story. It was only the 4 people on the property that were there.
All right, thank you, sir. And it's the people's position that you're moving to dismiss under Rule 48?
Correct.
Okay. Mr. Norp, any record you want to make on this, sir? Or any further information
No
you want to
record.
provide?
No record, no objection, Judge.
All right, Mr. Robinson, a couple of things I want you to know. First of all, the court does not have the authority to compel the district attorney's office to move forward with a criminal proceeding. So if they make a determination that the evidence does not support criminal charges, The court doesn't get to second guess that. The only basis for the court to intervene in something like this is if the court found that the decision was being made in bad faith. And that's why I asked Mr. Allen to articulate on the record today as to the reason why the people are seeking to dismiss. I recognize from the factual recitation that I've heard today, and I'm aware from the arrest affidavit, that you suffered serious bodily injury as a result of this altercation. Unfortunately, the court cannot compel them to move forward with a criminal matter, and I have to grant the motion to dismiss based upon the record that's in front of me. That does not mean that you are not, that there is not a possible means for you to get some type of satisfaction. Even though the criminal case is being dismissed today, you have the right to bring a civil action if you'd like to, with respect to your injuries against these individuals. What the court cannot do is compel the state against its wishes to move forward with a criminal proceeding. Do you understand that, sir?
Somewhat. Why is their story more justifiable?
It's not a question.
Of course, the three of them are gonna. Of course, right? So
It's not a question of whether their
it's a little like-
story is more justifiable.
It's just a matter of then why don't we explore it then?
Because it's not the way a criminal case works.
That's
So the
mind
people-
blowing.
I know.
Like,
The people have to be convinced, and they would have to convince the court that they could meet their burden to show the allegations or the charges beyond a reasonable doubt at trial. And
I
they've
have
made a
3 fractures in my
determination.
body.
That part I understand, but that doesn't necessarily mean that the underlying allegations are criminal actions.
Well, it doesn't necessarily mean the other thing either.
It does not,
Right. So
because they have to
What's
prove
that?
it beyond a reasonable doubt at trial. So it's not a question of, is it more likely than not that it resulted from criminal conduct? The evidentiary burden is very high. Again, the district attorney's office gets to make that decision without the court being involved. And the only way the court can say no is if I find that there's actual bad faith. And that's why I required Mr. Allen to articulate on the record as to what the allegations were. Again, do you understand that you have the right to bring a civil proceeding?
you mean
against-
sue them?
I do. That is
And
what I
that's
do.
all my money, right? And it's all my. Again, it's like wow, it's really wild.
Well, because the only time that the state can be the actor bringing charges is if the state is convinced beyond a reasonable doubt that criminal conduct occurred. And so the people are not convinced of that, and therefore they're moving to dismiss. And the court has to grant that request, given the record that's in front of me today. It does not mean that I believe the state over you or that I believe the 3 defendants over you, because I don't have enough information to make that decision. But I do not have a basis to compel them to go forward with the criminal case. Based upon the information the court has in front of it today, the court's granting the people's motion to dismiss pursuant to Rule 48A with respect to Mr. Paulson. Mr. Robinson, what I would ask you to do, sir, before you make any decisions, speak to an attorney and decide if you want to proceed on your own civilly. Mr. Allen, can I ask, this is without prejudice, I'm assuming.
My DoorDash driver has just been driving around in circles with my coffee the whole time this guy has been testifying. Since before then, I'm watching him just drive around in circles with my coffee.
That's correct.
All right, court's going to grant the motion to dismiss without prejudice. If certain further information comes forward, the people are entitled to refile. Mr. Allen, anything further for today?
No, you're thank you.
Mr. Norp, anything further for today with respect to Mr. Polson?
No, Judge.
All right, Mr.
Well,
Robinson.
I just wanted to clarify everything I just said is for everyone else too. So I don't need to come back or anything, right?
You're welcome to stay and tell me again if there's something in particular with the other gentleman. I don't have any problem with you telling me that. And I want you to hear.
It's the same.
I understand. Mr. Robinson, I want you to hear from me. I don't know any of the underlying facts. I am not taking their word over your word. I recognize that there were 3 other individuals there and their story probably diverges from yours. I don't know who's telling the truth and who's not. I am fully aware of the injuries you suffered and the pain you've gone through. And so the only issue I can determine today is whether the people can be compelled to go forward with criminal charges as opposed to some other form of relief. And I'm finding they can't. Do you understand, sir?
Not really, but it's a courtroom, so.
All right. Thank you, Mr. Robinson.
See ya.
All right. Thank you, Mr. Norp.
Thank you, Judge. And there's an automatic seal.
Yes, it automatically seals. I didn't. We're gonna do this one.
I've reviewed the pre-sentence investigation report. Is there anything else that I should, and the cost of prosecution, is there anything else that I should have reviewed in anticipation of sentencing Ms. Tebow?
No, Your Honor.
I should also note that I reviewed the notice of removal of community, from Community Corrections and 23 CR 134. Mr. Albino, is there anything else that I should have reviewed from your perspective?
I don't believe so.
Mr. Sullivan, anything I should have reviewed?
No, Your Honor. Could we also call 26M 70?
I did, yes.
Okay.
Although I confess I did not review the facts in that case since it was a stipulated sentence, but
That's okay,
I
Your Honor.
can if you'd like me to.
I don't think you need to. It's a stipulated sentence.
I don't see anyone here today, so I presume that there's no one that would like to address the court, but is there any information from the victims that I should be aware of? Mr. Sullivan?
No, Your Honor. Okay, from the people.
Then I'll hear from Ms. Tebow then.
It's too hot to turn the fan off. It's way, way, way too hot. So yes, you can hear the wind blowing and my mind keep changing over and over and over again. That's what it's like when in June.
I'll hear from the attorneys for the prosecution. Then Mr. Frazier, I'll give you an opportunity to tell me anything you like before I impose sentence. Do you need the white noise, Ms. Tebow?
No, Your Honor.
All right, Ms. Tebow?
Your Honor, I think the biggest question for the court is what sentence to impose in 23 CR 134. That is the community corrections removal. The other two cases both have a stipulated sentence. What we're requesting is a straight conversion to 4 years in the Department of Corrections. That is still a significant sanction for Mr. Frazier. And to me, I think these cases are really about Mr. Frazier's mental health and his ongoing attempts to receive treatment and care for his mental health. Once he is out of DOC and on parole, his goal is to get treatment through the VA for his mental health. And the sooner he is able to get out of the Department of Corrections and onto parole, the sooner he can look into those inpatient treatment options through the VA. I know that Holly, I think it's Neasley from the VA has worked throughout my representation with Sean on working to try and get him into treatment various times. And so that's an individual that he could reach out to once he's on parole to get treatment set up. In terms of mental health, Mr. Frazier does have a
Violet, I appreciate you. I do.
Diagnosis of PTSD from his time serving in the United States military. Through the VA, he is 70% disabled for PTSD. My assumption based on that is that they think that PTSD is a significant factor in Mr. Frazier's life to give him 70% disability for that rather than a smaller amount. He is a veteran of the Army and he served in Iraq. He was honorably discharged as a sergeant with the level of E5. During his period of time in the military, he did 2 tours of duty from 2007 to 2008. He ultimately was enlisted in the military in 2005 when he was a young man. The reason he enlisted is because he was looking for work and trying to find a job and was unable to do so. There wasn't any stable work for him. He was looking at temp agencies and he had just recently had a son, his first child, and knew that he needed to step up and take care of his son. And so in order to do that, he ultimately joined the military. His son turned 1 year old 5 days after Mr. Frazier was shipped out to Iraq on his first tour. And then while in Iraq, Mr. Frazier missed his son's first 3 birthdays. So he was not only serving this country, but he was also away from his family in dealing with separation from his son during a very critical time. And the reason he joined the military is really for his son in order to care for him and give him the best life possible. His son's name is Landon, and Landon is now in the military himself in the Army and is 20 years old. When Mr. Frazier was in the military, he saw active combat. He served in Scania, which was a place where there was very significant active combat. While Mr. Frazier was there doing his tours, he regularly saw bombs exploding. He's described to me witnessing people have their limbs getting blown off. At one point in time, Mr. Frazier's Humvee was hit and he was blown out of it and ended up across the road. There were mortar fires really every morning during his time in Scandia. His sergeant was hit and lost his leg, and he lost some friends who had really become his family at that point. Mr. Frazier turned 21 while he was overseas in Iraq serving. He went into the military at 20 and then had his 21st and 22nd birthdays there. One story that really stuck out to me when I was speaking with Mr. Frazier about his experience in Iraq is that he had a best friend in his unit with him. They would trade off being the lead gun truck while they were traveling around the area because the lead gun truck was the more dangerous truck to be on. His friend was about to be done with his enlistment, and it was his last ride before his friend was going to be going home. It was his friend's turn to be in the lead truck, and Mr. Frazier said, "No, it's your last time. Like, I'll take the lead truck." And his friend insisted that it was his turn, and he took the lead truck. And unfortunately, the lead truck was hit, and his friend died. And his friend had just had his son 2 weeks prior to that. And Mr. Frazier really struggles with the guilt of that experience and feeling like that was his fault. When Mr. Frazier got home, he experienced sleeplessness. He couldn't sleep. He had nightmares when he did sleep, and that caused marital problems for him. He had trouble getting up for work because he had sleepless nights and nightmares, and he ultimately started using methamphetamine in order to keep himself awake because he was awake during the day because he had been up all night dealing with his mental health. As part of his PTSD, he struggles with loud noises. He doesn't like feeling like loud noises in his chest, like fireworks. In terms of the resisting arrest, in that case, there was a flashbang, and that was very scary and triggering for him and his PTSD because it was reminiscent of his time in Iraq. In community corrections, prior to going to community corrections, there was very clear and consistent mental health issues in the jail for Mr. Frazier. I reviewed jail medical records, and they indicate that Mr. Frazier was on suicide watch from July 17th to July 22nd of 2022, from August 15th to August 25th of 2022, from September 9th to September 28th of 2022, from March 3rd to March 25th of 2023, from April 28th to May 21st of 2023, from January 26th to March 6th of 2025, and then in November of 2025, November 23rd specifically. So it's clear that he was really struggling with his mental health in the jail. My understanding of suicide watch in the jail is that it's incredibly onerous for people to be on suicide watch. They often are placed in booking, which is a very difficult area to be in the jail because it's where individuals who are coming into the jail are processed. And so there's a lot of turnover. It's often very loud in there, and there's a lot of disruption. You're also placed in isolation when you're on suicide watch. And so in my experience, clients in the jail often are reluctant to go on suicide watch. And so it indicates to me that Mr. Frazier was really in need of that care since he was forthcoming with his suicidal ideations at those times, knowing that it would result in him being placed on suicide watch. In terms of his diagnoses, as represented in the records I reviewed, he's been diagnosed with major depressive disorder, reoccurrent on, that was referenced in the medical records on May 7th of 2023. He's been diagnosed with PTSD, unspecified mood affective disorder, substance-related disorders, anxiety disorder, bipolar disorder, and mood disorders. There were also a large amount of sick calls mentioned in the medical records. Initially in May of 2020, there was a note that indicated there were signs of developmental disability, slow speech, appearance, or history. In June of 2020, it indicated that patient was seen during MedPass, highly distraught and crying. Multiple concerns and complaints for life on the outside after release. Please evaluate. And then that was canceled based on patient being released from custody. In July of 2022.
So it does break my heart, Bren. I have fiber right now because I need internet. My car was held together by duct tape. I didn't know, where dinner was coming from, but I have fiber internet. And there's no such thing out where I'm moving, and there's no wired. I have wireless. And it's being mailed to me. And it's plug and go. So I'm waiting for it to be mailed to me, and then I just plug it in, and I'm not gonna have enough bandwidth. I already know this. I'm like, there's nothing I can do about it. I got the biggest package I could get, but even when you think you're getting a big package, you still get disappointed sometimes. We'll see what happens during that first stream.
There's a note that indicates patient is a Gulf War vet who came in extremely emotional and stated, quote, "I have nothing to live for," and quote, "I am tired of being here," as in on earth. Patient could benefit from a mental health evaluation. In August of 2022, it notes patient was on SW suicide watch during his prior incarceration and was booked in tonight feeling suicidal. Patient is highly emotional and is a vet who has seen active combat. December of 2022, patient has diagnosed with depression, is very sad with crying episodes, takes Zoloft 50 milligrams.
Take Zoloft 50 milligrams, Alan. Have a good flight.
Which he started taking 4 days ago. July of 2023, patient was tearful at medical visit, reports increased difficulty with depression, denied suicidal ideation. November of 2024, there was a kite that Mr. Frazier sent to jail medical. It says, "Need to get my meds, my Seroquel 200 milligrams for sleep."
Yes, JK.
November 23rd of 2024, again, a kite from Mr. Frazier to medical. "Please request my records for psych meds from the VA."
You forgot the last part. You're still not satisfied. That was the last part of that sentence.
November 21st of 2024. Patient reports being on lithium and Seroquel, records from VA, was on meds previous incarcerations. January 26th of 2025. Patient reports SI, suicidal ideation without a plan. Patient tearful during receiving screen. February 4th of 2025. Prior history of medication needs medication increase. Patient needs lithium ordered. November 25th of 2025, patient states he has medications through the VA. November 26th of 2025, records request for recent medication, history from VA. December 2nd of 2025, wants an increase in Seroquel, IPE stated he lost a stepson. Patient reports medical provider that he needs lithium. So it's clear that Mr. Frazier is, through the Kikes, reaching out and trying to get help while he is in the jail for his mental health needs. His prescriptions prior to going to ComCore, he had Seroquel.
My son just retired. He was Team Puerto Rico's #1 tank in Overwatch. So, semi-pro. Just retired. So with me streaming and getting a lot of videos and him playing Overwatch, like, he can't have lag. Just the slightest lag will get him killed so fast. So we needed good internet. My son has, his computer is, I can't say it without saying a bad word. His computer is still very nice. And our internet connections are very nice. Even his monitor, we had to get a special monitor so that, he doesn't have any lag. So he just retired, so he still plays Overwatch, but he's not semi-pro anymore. So I'm hoping that the new internet connection will be good enough for him. It won't be for me. I won't be happy. I already know I won't be happy. But in 2027, I'll be able to get Xfinity again, which is lower than I would like, but it's better than what I'm about to get.
From December 10th to 2025 to March 4th of 2026, that's an antipsychotic.
I hope you have
He
a
had
great
lithium
time,
carbonate
Alan.
from December 5th, 2025 to March 4th of 2026. That's a mood stabilizer that's primarily used to treat bipolar and manic episodes. He also had venlafaxine from December 8th of 2025 to January 30th of 2026. That's an SNRI for depression. After community corrections, he likewise had prescriptions in the jail, including Valium, which is used to treat anxiety and seizures and alcohol withdrawal, Keppra, which is an anti-epileptic drug used for seizures, trazodone, clonidine, venlafaxine, and lithium. When he arrived at community corrections, it's my understanding from speaking with Mr. Frazier that he wasn't given his prescriptions, which was really stressful for him because these are very clearly prescriptions that Mr. Frazier relies on, and not taking prescriptions even just for a brief period of time can have a very significant impact on mental health and brain function. He also was told by community corrections that he wouldn't be able to attend a hearing about his daughter's custody. The hearing for custody for his daughter was supposed to be, I believe, like the day after he was in community corrections, and he was told he wouldn't be allowed to attend. There was supposed to be a video call into court. I'm sorry, there was supposed to be a video visit that he couldn't do. He did try and call into court, but the judge terminated his phone call and granted his ex-wife's request. And it was following that he left community corrections. The court date was at 1 p.m. And that evening after dinner is when he left. He made a mistake and left, but he was going through a really significant mental health episode at that point. And he left out of frustration for not having his medications, not being able to attend this court date. And Mr. Frazier understands and recognizes that that was a mistake. And certainly converting his sentence to 4 years in the Department of Corrections is a significant sanction for that mistake. What we're asking for is that straight conversion so that Mr. Frazier can go to the Department of Corrections, serve his sentence and that punishment.
That's how it was at work yesterday, Mel. I am dripping in sweat. My hair tie was just, my scrunchie was just soaked. And all my customers were like, oh, It's so cold in here. Can you turn the heat on? It's so cold in here. I had thoughts of homicide multiple times yesterday. I can't believe I didn't get a felony yesterday. I can't believe I didn't catch a felony yesterday, but I'm a freaking professional. I smile, I make them happy, but I just want to, yeah. We had a bus, we had a bus full of kids yesterday. One of the buses, we had a couple buses. One of them was all kids, and it was like a military school. It is a military school, but maybe it's not. I don't know if it was a military school or not. All I know is a lot of them were orphaned. Not all of them. Some of them do have parents, but it was just a big bus of these children, and you know, we bring them for free, and we give them free popcorn and free sodas and things like that for them to watch the show that goes on. And we had a bus full of kids that all got free popcorn. So we do, this is just one of the buses. Okay, there's a couple different buses. The other ones were mostly elderly, very, very elderly, but I guess, I don't know, freezing to death, very elderly, because they were freezing. I told them, get up and clean some of my tables, you won't be so cold. They laughed. I was not joking. They're so cold, get up and clean some of these tables. Anyway, so we get through the shift, and it's just me and one other server, and you know, a couple hundred people. We get through the shift, we get almost to the end of the shift, and my boss calls me over and says, oh, by the way, the server that I work with, he has to go as soon as the show is over. He has to go. We have him doing something else. So you know it's not comedy. So you have to just clean by yourself. Yesterday was my daughter's birthday, Tiffany, and we had plans. But I had a bus full of kids that all got free popcorn. So it's a dinner theater, but it's not comedy. I've never seen comedy there. So I had to clean this entire room by myself yesterday after the show, before the next show starts. And when I say show, I don't mean like movie. It's not a movie, it's a theater. It's, you know, we have a whole cast that gets up. Yeah, it was a mess. I can't believe I didn't commit a felony yesterday. I just can't believe it. I have such great self-control. I just do. Bus full of kids all got free popcorn.
And then transition to parole, where he can reach out to the VA and work on getting treatment set up through them so that he can focus on
all the
his
swear
mental
words,
health.
all of them.
Thank you.
Not under my breath.
Do you have pre-sentence confinement numbers for?
Oh, I just have to add, I had them for our last court date, and I just have to add the most recent. So I can do that and have that for you after the DA's argument.
Thank you. Mr. Albino?
Thank you, Your Honor. The defendant was given a chance at ComCore. He was given multiple chances on probation in this case. He walked away immediately. So at this juncture, only the Department of Corrections is appropriate. The question is really the length of the sentence. He was convicted of F4 stalking as an extraordinary risk crime. And based on his performance on probation and walking away from ComCore, I'm asking for at least 5 years in the Department of Corrections. Stalking is based on repeated conduct by definition, and in this case, he was in violation of a protection order. And it's not like this is his first or only criminal conviction.
Oh, you know those words,
Stalking is
Monica.
recognized by our legislature. That's why it's subject to that extraordinary risk sentencing. Unfortunately, in Mr. Frazier's case, we've tried everything else. Multiple opportunities on probation, community corrections. We tried that rehabilitation. Now The value of the sentence is punishment, and it is to exclude him from society, to protect society. So for that reason, I'd ask for at least 5 years. Thank you.
Thank you. There's, it looks like $15 in cost of prosecution. Is there anything else that's being requested, Mr. Ovian?
I don't believe so.
Mr. Sullivan?
Your Honor, I'll just ask the court to sentence according to the plea agreements in the other two cases.
Any restitution or cost of prosecution being requested?
No, Your Honor.
Steve, any objection to that $15 in cost of prosecution?
No, Your Honor.
Okay.
And I have credit calculations.
Yes, please.
26 CR 35 is 147 days. 23 CR 134 is 412 days. And then 26 M 78 is 152 days. I think the difference is the PSIR, I don't believe took into account his time. I'm not sure why the numbers were so different, but.
Well, they were less than the numbers that ComCore gave me in the PSI, so I knew that they weren't correct.
Jeez, 26 months on one of the higher levels. Christy, thank you so much. I appreciate you. I do. It's nice to see you today.
Mr. Albino, any objection to the numbers in your case? Mr. Sullivan, any objection to those numbers?
No, Your Honor.
Okay. Mr. Frazier, what would you like to tell me? I think they actually prefer you to remain seated. It's okay.
I'd just like to apologize for ruining the opportunity that you.
See, some people were still members throughout my demonetization. Christy's one of them. I don't know how. You're amazing.
You gave me to go to ComCore. Wasn't in my right mind. I'm not trying to make any excuses. I shouldn't have done it. Looking back at it, hindsight, I wish I never did. If I had a chance to do it again, I wouldn't. I'm not a danger to society. I've made some mistakes in my life, and I'm here. I'm gonna pay the consequences for it. And I'm just asking if you. This isn't about me. It's about my daughter. I really need to get home to her. She's really suffering with this case more than I am, more than anybody. And I just ask if you keep her in mind while you sentence me. And I'm just asking if you can do the trade conversion of the 4 years from ComCore to DOC, please.
Well, Mr. Frazier, you were given a bunch of opportunities in this case to address the issues that you have. I'm not trying to suggest that those aren't significant issues. I know that they are. And I know that it's a difficult struggle, but you're not going to resolve them doing the things that you have been doing. You got to do the work, and it's hard work. And thus far, you've chosen not really to take advantage of the opportunities that have been presented to you. You've had 2 chances on probation. In the 23 CR case, you got the opportunity to go to community corrections, even though, as I recall, I expressed some significant concerns about that. And then you immediately walked away, like the next day. I don't think you're going to do the work, Mr. Frazier. I wish that you would. I wish that you would address the things that you need to address so that you can be there for your daughter, so that you can be a member of our community and be successful. But thus far, you've demonstrated to me that you're not going to do that. And I'm not going to reward bad behavior with just a simple conversion. I don't think that sends a good message to you. I don't think it sends a good message to anybody else. I want everybody to know that if you go to ComCore in front of Judge Chaffin and you walk away, things are going to be worse, because I don't want people to walk away.
I want everybody to know, if you mess with me, I
want them to stay.
So they're asking for 4 years, Department of Corrections, okay? That's what they're asking for.
And do the work. I think that an additional sanction is appropriate. In 23 CR 134, I'm sentencing you to 5 years in the Department of Corrections. I'm giving you credit for the 412 days that you've already served in that case. Standard and mandatory cost
He
fees and
added an
surcharges
extra
are
year.
imposed. Court orders $15 in cost of prosecution. Any previously ordered restitution, which I don't recall if there was any, but if there was, that remains in effect. In 26 CR 135, pursuant to the plea agreement, I impose a 1-year Department of Corrections sentence. That sentence is run concurrently, meaning at the same time with the sentence in 23 CR 134. I give you credit for the 147 days of credit that you're entitled in that case. In 26 M 78, I sentence you to 120 days. I give you credit for 152 days.
Look, I don't know if I'm going to look at any court videos during my 4 days off. I don't know. I have this huge backyard, and I think I'm going to go sit for 4 days. I'm going to sit. There's no computers out there. But if I get an itch to look at court videos, which I do for many hours every single day, I will get the marathon together and I'll do a marathon. I'll do a nice marathon. I got enough content. I just need to sit at the computer and do it. But it's going to be really hard to go to my computer when I have that backyard I can go to and sit. I do have to get a marathon soon, very soon. There'll be one in June, I hope. I will.
Your sentence is discharged. That sentence is to run concurrently with all the other sentences. In this case, standard mandatory cost fees and surcharges are imposed in all the other cases. No restitution is requested. None is ordered. Bonds in the cases are exonerated. Protection order in 26 M 78 and 26 CR 35 are vacated. Protection order in 23 CR 134 remains in effect during the period of the sentence. Your sentence will be followed by a mandatory period of 3 years. 3 years of parole. And 23 CR 134
All right, so
and 26.
What's his chances on parole? What's his chances that he's going to listen? And then he's going to get back in front of this judge again? Oof, oof, oof.
CR 135, it's technically a 1-year period of parole, but the way the Department of Corrections does is when you have concurrent sentences, they treat it as one single sentence, and so your period of parole is governed by the longest sentence. And so I actually have 3 years of parole in both of the cases. Ms. Love, anything that I'm missing? Mr. Sullivan, anything that I missed or any record that you'd like to make?
No, Your Honor.
Mr. Albino, anything that I missed or any record that you'd like to make?
I don't believe so. Thank you.
Ms. Tebow, anything that I missed or any record that you'd like to
I
make?
could. There's no neighbors
Mr.
to
Frazier,
see me.
do you have any
None.
questions for me?
No neighbors to see me.
I do wish you the best of luck, Mr. Frazier. There are services available to you in the Department of Corrections. Seek out those services. I often tell people to be selfish when they go to the Department of Corrections. And what I mean by that is to look out for all of the opportunities for you to improve yourself and to get the services that you need. Ignore all the nonsense that you're going to be exposed to because there's going to be a lot. That's how people come out of the Department of Corrections the better for it. Okay?
Yes, sir.
I agree with you that your daughter needs you. But I can't just say, oh, well, your daughter needs you, and so I shouldn't hold you to the same standard I hold everybody else to. I expect better than what I saw so far, and I hope that I see it in the future. Okay?
Understood. Thank you.
Good luck to you, Mr. Frazier. You are remanded to the Mesa County Sheriff for transfer to the Department of Corrections. We'll be in recess. Thank you, everyone.
Okay. Now I got a family who's fighting a lawyer. Here we go. I've skinny dipped many times.
Judge, I think we can call that Garcia matter.
All right, the court will call the Josue Garcia matter. This is 25T12064. Mr. Garcia is present with Ms. Alvarez. Mr. Houtsma is here for the people. I know that there are quite a few individuals who are obviously very interested in this case. They've been very patient throughout this case. I do want to thank them for being here today.
Judge, don't thank them until you hear from them, because you're not about to thank them for being here. You're about to eat those words.
And thank them for their patience here today.
They
Mr.
have zero
Houtsma,
patience. Zero.
what is the status of this case?
Judge, today is the third disposition hearing in your courtroom. We had one on January 26th. We had one on March 30th, and we're back here today, June 8th. Judge, we had an offer. It has been extended and available this whole time. I'm being told that offer is not being accepted, so we're asking that the matter set for trial.
Ms. Alvarez?
Your Honor, I at no point made an indication that the offer is not being accepted. I communicated all of this to Mr. Vandeven. The first time I found out that this case was Mr. Meinecke's case was Friday. Mr. Garcia has been trying to sort everything out with his insurance, which I believe is the record I've been making. The last time he heard from his insurance, they need some sort of affidavit that he's never been a rideshare, Uber, and that he wasn't doing that while this case happened. He's been told that he's going to be sent that paperwork. That paperwork still will not be sent. The insurance can't process or tell him what they're going to cover for the claim if he doesn't have that affidavit. But they won't send him the affidavit because the adjuster keeps telling him that the attorneys have to get this affidavit. It's obviously not Mr. Houtsma or me that they're talking about. So I'm assuming it's the attorneys on behalf of the insurances. I understand that this case has been continued those 3 times, but also the charges in this case aren't nothing. So while I understand that it's difficult for the victim's family to be here, I do just want to state that the communication I've had with Mr. Garcia, and I'm not minimizing, but I do think it's important.
If only we could hear what the victim's family actually thinks. If only we had a way of hearing them.
Important to note that it's also, this was an accident. Obviously, Mr. Garcia did not have an intent in this case, and it was a traumatic experience for everyone. I'm not saying that he feels the same way that his family members feel, but Mr. Garcia is also struggling with all of this. It's been very difficult for him. I've been trying to see if we can get him also into something, because I do believe he needs also more than I can provide as an attorney. There's only so much I can talk to someone about in regards to having something like this on your conscience. It's not something that Mr. Garcia is not taking the offer just because he wants to drag this out. But I do think in a case like this, it's also important to note the amount of money that could potentially be an issue that he needs to get from his insurance. So I don't know how to make the insurance get that paperwork. I'm not the civil attorney on behalf of the insurance.
Just so you know, I'm not saying that this family is wrong. They have an opinion.
Okay. Well, Mr. Garcia, the charges in this case are exceptionally serious. The case has been pending for 224 days. There are a number of people who continue to come to court, including yourself. I think that moving this case forward is probably in everybody's best interest at this time. So the court will accept a not guilty plea on your behalf. We will set this matter for a motions hearing, a status conference, and a jury trial. If things continue to develop between Ms. Alvarez and Mr. Houtsma, I'm happy to do whatever we need to do at that time. But I think moving this case forward is in everybody's best interest. Okay, sir?
Would the communication I have with my insurance company, I mean, I have I made a verbal statement for them stating that that I was not working for any rideshare companies at the moment, and have never had any rideshare companies. I've never worked for any rideshare companies ever, but they also asked for me to send them an email, which I have an email on my phone. For whatever reason, that wasn't enough for them. And the last I spoke to my adjuster, he told me that he would send me the paperwork and that I would have to sign and notarize the paperwork and send it back. So what I'm getting at is just I have an email on my phone with that last email that was sent to them, confirming and just stating from my side that I have never worked for a rideshare. So would someone looking at that be enough to be able to set another court date? So just because that's where the process is at, and I'm doing everything I can on my side, and just as I'm kind of
Well, and I want you to continue to do that. Okay. I know sometimes, especially when we are dealing with insurance companies, some of the actions and some of the delay is outside of our control. This doesn't preclude you from continuing to work with your insurance company, continue to try and find out what that number is. And if there's a resolution as this case progresses towards trial, I'm more than happy to address that at that time. Okay. But given the age of this case and given the number of people that are involved in this case, I do think that moving it forward is the appropriate thing to do. Keep working with your insurance company, keep working with Ms. Alvarez. And then if we need to add this case on for whatever reason, or if we need to address some type of motions, we can do so. All right, Mr. Garcia, I'm going to give you those court dates. I want you to keep working with your insurance company and certainly keep Ms. Alvarez in the loop. Okay, sir?
Yeah.
All right, we're going to do motions on September 9th at 10 a.m. The court is going to order that all motions be filed within 35 days of today's.
Judge, it's still January of 2026. You're setting something for September? Holy crap, half of the year is gone already? What? How did that happen? Guys, we're almost in the second half of this year. Monica, thanks for the cheers.
Date. Is September 9th acceptable for the parties?
Fine with the people.
Okay.
we be able to talk for a second.
We can talk.
We'll do trial on October 20th at 8:15.
He took his wife, and they want to do just not. Bring back
Can it be sooner? I mean, that's the anniversary, pretty much around that time that he passed. And this has been ongoing, and we want this to just be done.
No, and I completely understand that. We go a little later. Unfortunately, given our trial docket, we can't go sooner. We could choose a different week, a few weeks later, if that.
Right. The date of offense here was October 4th, and I did let the family know I expected we might be setting sometime around then. Obviously, that is upsetting to them, as you're hearing here today. I don't want to get too far out close to Speedy, so I'll talk to them, but I think if we should accept the date that was offered. I understand we can't. That's the earliest the court's offering us.
So what is the earliest you're offering again?
October 20th.
Okay, we'll keep that.
Okay, we'll do October 20th at 8:15 for trial, and that will give us a status conference on the date of offense was October 4th.
Correct.
So we're looking at status on October 7th. Now, status is just everyone telling us whether or not we're actually proceeding to trial. That's not a day for litigation necessarily, but that would be our date to check in and see if we were still going to trial.
Right. Now I understand, and I'll talk to them about that.
Okay. What was the other one we could do if we wanted to? the day before. So we'll do status October 7th at 9 a.m. Now, I know this is an extremely emotional case for everybody, and I can't imagine what they're going through in this matter. It's my perception that everyone is staying in good contact with the parties they need to be in touch with. If there are any new developments in this case, I would, well, let me put it this way. If there is going to be a resolution in this case, I would be more than happy to do that as an add-on. We just have to make sure that all the appropriate parties have an opportunity to be notified and to be present for that. But if there is a potential resolution, I'd be happy to add it on to the docket as soon as we can accommodate that.
Yeah, and so let me just let in terms of the communication, this case was assigned to Mr. Howe, who left the DA's office a few weeks ago. We had made an offer at the sort of beginning of the case with a specific recommendation from the DA's office based off some VRA input we had got at the time. As the matter has progressed, the input has changed in terms of what they were hoping to see in terms of either a probation or a jail sentence. Before Mr. Howe left and he'd staffed this case with me, I told him to let defense know that today was the day to take the plea or it was vacated. It's my understanding from Ms. Alvarez, it sounds like maybe that wasn't properly communicated to her. Because when I'm asking her this morning, you understand this means the offer is revoked, she's telling me, no, I never was told that. The family wants the offer revoked today, but I just need to follow up and see if that was previously communicated or not. If it wasn't, then my intent would be to allow a 2-week period from today, so till June 22nd to have that offer accepted. And if it is, then we'd talk to the court about adding it on or not. But if I have information that we had previously relayed that today was the day to take it and it wasn't accepted, well, then that offer is vacated. So, and right, we need to communicate with defense counsel so we're on the same page with that.
Yeah, because it would also be important that was communicated to Mr. Garcia, obviously. Otherwise, we run into a completely separate issue.
Right.
But Mr. Garcia, I know you have a lot of things that are happening and a lot of things to discuss with Ms. Alvarez. But as it stands today, you understand that the district attorney's office has stated to the court that if there is not a resolution by June 22nd, they are going to withdraw that previous offer that was extended. Do you understand that, sir?
Yes, Judge, I understand.
Okay. Yes, ma'am?
I just wanted to state that she's been the attorney the entire time, so she has been aware of it and she hasn't been sympathetic this entire time. Oh my God.
Your Honor,
Well, hold on.
The entire time. I just wanna
Yeah,
she's lucky I haven't went off on her.
Well,
She's been aware.
Hold on.
She's lucky I haven't went off on her. What? You can't threaten a lawyer, ma'am.
Hold on.
And yes, you have.
Ma'am, Ms. Alvarez, stop.
Yes, you have.
Ma'am, you need to stop as well. I know this is an unbelievably frustrating and horrible situation for everybody involved. Ms. Alvarez has a specific job to do in this case, as does the district attorney. I need to let the parties do their job. I need to make sure that Mr. Garcia's rights are being followed in this case. And I understand it is not the responsibility of the victim's family to do those things. I wouldn't care about those things if I were in your position either. But I do need to make sure that his rights are being followed so that we're not doing this again 3 or 4 years from now.
So they understand what is going on.
Do we need to be present every time
It's not being understood.
Well, it is the responsibility of the district attorney's office to document those communications, and I'm confident that Mr. Houtsma is going to do so. Today, on the record, the district attorney's office has stated that the offer will be withdrawn on June 22nd if it is not accepted. So that is now part of the record. any communications that occurred between the DA's office and the defense attorneys in this case outside of the court's presence, I can't comment on, I don't have access to, okay? So I have to trust that Mr. Houtsma is going to look into those things.
But she's saying that she's not understanding. So if she's not understanding,
Never said that.
do we need to get interpreters for the both of them so they understand what is going on?
No, I believe that Ms. Alvarez understands what is happening here today. And Mr. Houtsma will clearly communicate to her going forward.
She understands what's going on today.
Ma'am, Ms. Alvarez is doing her job with Mr. Garcia. I trust that she is representing him to the best of her ability, and I trust that Mr. Houtsma and Ms. Alvarez will be in clear communication with each other going forward, okay?
Thank you.
All right. Thank you, guys. Mr. Garcia, do me a favor. If you'll take a seat, give us maybe 5-10 minutes before you exit the courtroom, okay, sir?
Don't leave that woman. You're lucky she hasn't gone off on you yet. She's mad at the defense attorney, which we get mad at defense attorneys when we don't have any skin in the game. Like, we don't know the victims, we don't know what's going on, and the defense attorneys just seriously tick us off. Imagine if we were victims, or if one of our family members were killed because of this defendant, and then we had to go and deal with these defense attorneys. Oof. Yeah, I would go. I'm with her. I understand. I understand how she feels. Though he's saying it was an accident. I don't know if it was a DUI. I don't know what anything about that case other than what just happened. But she's at her limit with the judicial system. October is a long way to wait for justice, if there is any. Because if it was an accident, she's going to leave very, very, very sad that day. Anyway, guys, thank you so much for coming out. I really appreciate it. I'll see you tomorrow, and then I'll be off for 4 days. Behave, guys, okay? See ya.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,